Good afternoon, everyone. On behalf of New York MBA President Sherry Eccles, our Executive Director Joel Culver, and the entire New York MBA Board, thank you for joining today's webinar. My name is Elizabeth Shaney, and I'm proud to serve on New York MBA's Education Committee alongside my co-chair, Bill Kennedy. Before we dive into today's session, I would like to update everyone on upcoming MBA November sessions. We have our 10 on Tech with Jackie Groslick on 11/18 featuring Jim Carroll. And we have our Affordable Friday series on November 21st. Now, before we begin, just a few housekeeping items. If you experience any technical issues during the webinar, please notify us using the chat function. All participant lines are muted except for our presenters. We encourage you to ask questions throughout the session using the chat or Q&A functions. After the webinar, we'll share the presentation slides and relevant resources with you. Stay connected with New York MBA. You can find us on LinkedIn at newyorkmba.org. and on our YouTube channel at New York Mortgage Bankers Association, where we post webinar recordings such as this one. Lastly, I urge all mortgage professionals to consider joining Mortgage Action Alliance. It's free, easy, and a fantastic way to stay informed about legislative issues affecting our industry. And now I have the pleasure to introduce today's guest speaker, Cody Nett. Cody is the Chief Legal Officer for Everett Financial, Inc., which operates in business as Supreme Lending. Prior to Supreme Lending, he was General Counsel and Enterprise Risk Officer at Union Home Mortgage Corp. As a CLO and General Counsel for the past 12 years, his experience includes working closely with C-suite executives and senior leaders on all matters affecting the residential mortgage business. He brings deep expertise in large-scale mergers and acquisitions, high-stakes litigation, commercial contracts, labor and employment-related issues, compliance with corporate governance, securities regulations and filings, and other regulatory matters. Today, he will engage in conversation with our past New York MBA President, Jeff Pinard, to help our attendees navigate legal potholes with employee recruitment. So please join me in welcoming both Cody Nett and Jeff Pinard to today's sessions.
Thanks, Liz. Thanks.
All right.
Jeff, thanks for inviting me on.
Yeah, now this material is excellent, and Cody, maybe we should just start with why now is like the right time to be having this conversation and this dialogue. I think there's a lot going on in the industry, but I'm going to let you just elaborate on like why now should we be having this.
Absolutely, Jeff. I think you can see it in the news, you see it in the rags, you see it in the email blasts all the time, but litigation in the industry is at an all-time high. I think movement in the industry is pretty high, which begets litigation. And so in the recruiting efforts, in an attempt to avoid that litigation, there are things that you should do and watch out for. And I think that's what makes us a perfect time for it. Like I said, there are some pretty huge damage awards out there in the litigation, and it seems like every other day there's a new lawsuit coming out.
Excellent. Yeah, I know recruiting is top of mind for pretty much every mortgage professional right now. So I agree. This is a great time for this conversation. So all of us in the sales side, which is where most of this litigation, I believe, happens, have agreements with our companies, and they vary, I'm sure, by company, position, and position. But I bet there's some things in those agreements that tend to get us into trouble, and maybe you could just speak to that a little bit.
Yeah, absolutely. And Jeff, let me start with nothing that I'm saying today is meant to be specifically legal advice for anyone on the call, right? It's more of an overview of the things I've seen in dealing with these, but state laws, there's all kinds of difference. So, I mean, by all means, consult your attorney as well. This is sort of just a guidepost. As you mentioned, I think probably 90% of professionals in the industry have some sort of an employment agreement with their employer, and probably 100% of those agreements contain some form of what we like to call restrictive covenant. And most of the time people would think that means a non-compete, but that's really not the case. And especially in today's world, non-competes really aren't as prevalent as they used to be. They're not something to worry about as much for various reasons. Courts not enforcing them, the White House trying to strike them down. And so the things that you worry about now are non-solicitations of borrowers, non-solicitations of employees, referral sources, and confidentiality trade secrets. Those are like the 4 or 5 categories of what I would call hot button items that are contained in almost every employment agreement. For anybody, heck, most operational people even have them in their agreements in the industry.
So I'm hoping you're going to go a little deeper into each one of these and really educate us on what it means when it says you can't solicit borrowers or you can't solicit employees. So I'm hoping you go a little deeper there.
Yeah, absolutely will. I'll hit on each one of these. And what I'll say to you, and I think to everybody else out there, the material I have is pretty light. I think we all are fairly familiar with these clauses at a high level. And so this is meant to be interactive. Please ask questions. Jeff, pop in whenever you want, something comes into your head, but everybody out there ask questions. This works a lot better with real world examples.
Just put it in the chat.
So we'll start, non-solicits of employees, and I will tell you, everyone, that in my opinion, this is what most of the litigation centers around. This is the big topic, right? I mean, we'll go through all of them, but non-solicits of employees is huge. And what do we mean by non-solicited employees? If you leave your current employer and you have a clause in there that prevents you from soliciting employees when you leave, that means you can't talk to people at that employer about coming with you to your new employer, in simple terms. And, each agreement varies by definition of employees that can come. If there are people that are exempted from that, the length of time could be a year, could be 2 years. We've seen even 3 years. But the simplest, boil it down to its simplest form. Don't encourage people to leave their employer to come with you to a new employer. And if you have that clause and you do that, you would be in violation of it, and very likely your employer is going to come after you. I don't know, Jeff, you have any stories or questions from your world?
I would just ask for clarification. So I leave and I don't solicit them, but employees call me. Hey, how is it over there? What's going on? They're asking a lot of questions. How should I handle those sorts of inquiries?
Yeah, I mean, listen, again, it's very contract specific, but I mean, I tell people you shouldn't have any discussions about what it's like. You shouldn't, because if your contract says indirectly solicit or encourage, I mean, anything you talk about as far as old company, new company, how great it is, all falls into that. And, we tell people you're not to engage in any conversation like that. Now, the person that contacts you is free to talk to whoever they want. And so, we would suggest you say, if you want to talk to somebody at the company, email HR or email, person X, and you can talk to them, but I can't talk to you about this. And I mean, that is the safest way. And, we hear all the time, well, I've been friends with them forever, or, we've worked together for 25 years. And I mean, I get it, but the contract doesn't say except for those people that you're friends with, right? And so that's a misstep that we see all the time.
And I'm assuming text messages, emails, phone records are all fair game once you get into the legal
100%.
legal part of
Emails
it.
come out, texts come out, social media messages come out. Yeah, I mean, listen, phone records come out, and so, you may think like a verbal conversation that you've had will be fine. Well, maybe it will, maybe it won't, but the best advice is to send them to another direction at the company and you stay out of it. That's the safest. You know, the other point would be we tell people, the company can recruit all of these individuals, right? You can't, but the company can. And so the company knows who they are and they can treat each one as an individual and recruit each one individually. As long as they don't have a non-compete, there's no rule that says you can't hire them. It's simply that, you as Jeff Pinard leaving a company X can't solicit employees of company X.
All right. Well, that makes that clear. So you mean not only can I not talk to my ex, coworkers, I can't take all my pre-quals with me when I go to the next company?
Yeah, that's that's exactly right. Exactly right. And again, I'll keep harping on, and I guess one thing I would say is get the contract during the recruiting process and read it and see what it says. Because non-solicitation of employee clauses are fairly standard. They differ a little bit, but they're pretty common. Non-solicitation of borrowers and customers are very different by company. The way it's defined, who they say you can talk to, who they say you can't. It's really a a case by case factual determination when you review the contract. And Jeff, I don't know if you're guilty of this, but what I hear all the time is they're my clients. Well, it's not what your contract says most of the time. They're not your clients, they're your employer's clients. And if you take action to divert loans that have been pre-approved, your employer is going to see that. And if it's a violation of your contract, they're going to come after you.
I know salespeople, myself, struggle with this because we have the personal relationships with the customers. So we feel like, well, we have the relationship, they're our clients, but, legally, they're my employer's clients. And I will tell you, this is a hot button just because from personal experience, with regulators. Regulators very much, there's a reason my license has to be tied to a company license because the regulator is going to hold the company accountable for everything, and that's the way they want it. And so they get really upset if you take information from your employer because your employer is the one charged with protecting it. And sometimes it can happen in a very innocuous way. And the story I have is just that DFS, it happened to be, requested some files because they felt like a loan officer that had moved may have taken some customer information with them. And it just so happens to turn out that they had issued a pre-approval letter at their old employer. That pre-approval letter got attached to a contract and submitted into the new employer. And when DFS saw that, they immediately extrapolated that this person clearly had taken information they shouldn't have, and there was repercussions as a result. So regulators, not just lawsuits, are also keen on this information.
100% right. I mean, right, it's NPI, it's non-public personal information, and it was sent to a company. Now, again, it's my client, but it's not. It's the company's client. They're charged with protecting that NPI. And if you take it, there are going to be repercussions. And so I would say, listen, we live in the real world. I get it. There are times when something happens. Maybe a customer decides not to go with your original employer. Maybe the loan falls through. I get it. And you may work with that customer. Maybe they reached out to you and you didn't solicit them and you're working with them again. Well, under no circumstances should you take the documents that were presented to your former employer and use those to do their loan at your new employer, right? It should all be brand new. You have to start over. That's a really good point. Another piece of that is quote unquote stalling or diverting loans while you're in the transition. you're still employed. And so sending loans to a competitor is a problem and 100% going to be a violation of your contract. And I know, it happens. But again, the emails come out, the texts come out, and it's really easy to prove. And it's really a pothole it's very easy to step in. So, I don't know how people out there solve for that, but generally what you see in the industry is when you're transitioning, you're probably getting a guarantee or a sign-on bonus or something like that, right? That is payment for those loans. Leave the loans there. You have a non-solicit. It's not worth the headache that it's going to cause you for taking a few loans. Anything else
Agreed.
on there, Jeff?
No, I mean, I would ask the big question that all loan officers, hey, I have my database. Can you talk about databases? Because every loan officer's got one.
Yeah, that's a tricky it's really a tricky area, I would say. I mean, you're right, every single loan officer has one. I guess what I would caution people about is downloading things from Encompass or CRMs or things like that to take with you, even if it's your customer list. That, companies can see that. We see it. We see when you go in and download that. And we would consider that our information. Now, Jeff, I don't know if you do it, but a lot of people keep a separate Excel spreadsheet with, um, you know, phone number, address, name, email. That stuff's probably a gray area. It's not NPI and it's, you're getting it directly from the consumer. I think that, again, not exactly legal advice, but I think most companies understand that. But if you're going onto their system and you're downloading a CRM and it's got all sorts of information on there, and loan rates and close date and product, and then you're getting into some territory that I think you're going to have a problem.
All right. Yeah, no, that's, it makes sense, even though, again, not unlike the customer relationship, the
Yep.
LOs seem to have a mindset that that's my information, but it's really not. So,
Yep, it's companies. You have an employer and your contract probably says that they own it. And so, again, be careful about what your contract says is all I can say to that. Next piece is confidentiality. This one's really, it's an easy tripwire for people. Again, I would say the customer list falls into this, Jeff. And this is really just like a tag on. So they're gonna, you're soliciting borrowers, you're soliciting employees, they're gonna tag this on as a cause as well. They're gonna say you used confidential information to solicit these people. If you're emailing your stuff to a personal email, which we see, don't email company information to take with you to a personal email. Like you said, company lists, pre-approval letters, all those things. And as you can see, the very bottom there, it's what we talked about. This is how it's done. These are mine. I brought this when I joined them. None of those things trump what your contract says, which is a definition of confidential information and that you can't take it. And again, this is all going to be very dependent on what your contract says. Everybody defines confidential information in a different way.
all right.
Anything on there? Any questions?
No, nothing there. I mean, that seems pretty straightforward. But I know as an employee, we have certain obligations to our employer, and might not, might be in the contract or might just be the employer-employee relationship. There's a certain expectation. So, I think you're about to go into that a little bit. Like,
I am. Yep.
What does that mean?
Yeah, so I mean, you're exactly right, and I'll tell you, this has been something that's been fairly new to me, as far as litigation is concerned. But in the 10% of cases where you don't have a contract, or if your contract doesn't have a non-solicitation or a confidentiality or whatever, there is, while you're employed, you have a duty of good faith to your current employer. And what that means is, while you're working for them, you have to be working for them. So you shouldn't be talking to people about leaving. You shouldn't be recruiting people while you're working there. You shouldn't be taking information that's the company's for your personal benefit. Basically, it centers around getting ready to leave, right? And so if Jeff thinks I'm going to go to company X, and then he starts talking to 10 people at the company before he resigns, and he thinks to himself, I don't have a non-solicit, I don't have an employment agreement, I'm fine. That's not accurate. And, you can imagine that companies and the courts don't really look favorably on that kind of activity because, again, presumably you're still getting paid while you're working to actively undermine your current employer.
Hey, Cody, we had a question come in the chat, and they want to know if a loan officer brings over their customer information from their old company, and the new company is aware, or at least should be aware because they probably loaded it onto their system. Who ends up being liable in that lawsuit? Is the MLO? Is it the new employer? Both?
Both. Could be both. Yeah.
And do typically people go after the individual, or do they typically just go after the other company?
Both.
Both.
Yep.
Okay.
Yep. I'll be honest, I don't really know the reasoning behind it sometimes. But you see both. And I think that, a lot of times the new employer does what it can to protect itself from that type of stuff. They'll conduct training, and they've got people that are supposed to be looking at it. And so, when it's a claim like that, it's probably just the individual. They may bring it against the employer. You see them bring in the other companies when it's solicitations of employees, and they'll claim that the employer encouraged you to violate your agreement and helped you violate your agreement by soliciting people. And that's where you'll see both the employee and the employer named. But the employee is always liable because they're the ones committing the act. Right?
Well, I was gonna ask this later, but now seems like a good time. Like, I don't know that most of us see these lawsuits. Obviously, you do because of the chair you sit in. What are we talking about here? I mean, are these substantial awards?
Yeah. Yeah, they're very substantial. Right, Jeff, to your point, they could be, they could be six figures, which is substantial in the real world, right? But there's been recent cases where there's been verdicts $25 million. So to your point, and it's a good point, and people don't, because they're not exposed to it every day, or it's just not their world. It's a real threat, right? And there's real potential for damage there, 100%.
Yeah, I think most loan officers don't appreciate how quickly that number can get really big just by taking a database or something like that.
Yeah. And, so set the money aside, which is significant. A lot of people don't think about the stress and disruption in their life that it can cause. I don't know how many, or if you or how many people out there have sat through depositions and had to answer interrogatories and go to court and testify. It's not fun. Takes days, weeks of your life away, and it's stressful. It's not a fun thing to be involved in, for sure.
Well, the other thing I've seen is the person bringing the lawsuit will also write a letter to the regulator, and that regulator, while they're sorting it out to find out what happened, will not allow you to use your license. So now you can't earn an income and you're going through all this legal stuff. So it can be a very stressful thing.
Yep, and a judge could enter an injunction against you as well, preventing you from working because you violated certain clauses in your agreement. There's a number of ways it could go. You're 100% right.
All right. Well, I think we should probably keep moving forward. And if any other questions come in, I'll throw them out there.
Yeah. So I mean, Jeff, those are the big, what I'd call red flags or hot button items in your contract. It's what you should look for. You should get it and you should review it or have the attorney review it during the recruiting process 100%. Again, because they can provide you the legal advice on what the contract says. They're all a little bit different. I would say best practices, these are things that I look at when I'm thinking about how to comply with employment agreement. But, number one, and you hear this all throughout the industry, is the team, right? The Jeff Pinard team or well, when you're recruiting people that have a non-solicit, you shouldn't be recruiting teams. You should be recruiting individuals. I should be recruiting Jeff, and I should be recruiting Joe and Jill and Emily, right down the line, each of them individually, right? I'm not bringing on Jeff's team. Again, don't talk about other employees with them if they've got a non-solicit. One thing that we do is, we go through and require the employee to acknowledge that they may have restrictive covenants and that they're not violating them when they come over. So that's an important thing. It's one, it shows that the company cares, but also we're bringing it to your attention so that it keeps you safe as well. Train recruiters, conduct a legal review of the employment agreement. All those things can help your recruiting process be a little bit more efficient. Again, this is just sort of a rehash of what we've talked about, but don't use data from your former employer, any of it, customer, employee, compensation data. If they have an employment agreement, don't encourage them to breach it. In fact, encourage them that they should stand down. And then if there's people you want, you'll recruit them. Don't solicit loans. Don't talk about teams or bringing people with you. Leave loans there. All of those things. You could say individual performers, right? Rebuild the book of business. We want a clean transition. I always tell people, I don't even want you to bring a pencil. We want you. That's it. And then, if you've got incoming recruits that have it, this is what you can tell them. Don't contact coworkers. Don't encourage people to resign or apply. If people reach out to you, direct them somewhere, but you shouldn't be encouraging it. You shouldn't be texting or emailing people, obviously. The company should handle anything individually. Don't take anything. I mean, it seems simple, right? It's like I said, there's not a lot of heavy material here. But there are a lot of potholes along the way.
I would bring up, some of this is just, falls under do the right thing, but it also on your way out, I always encourage there to be some dialogue about, because there's going to be people in the pipeline and they're going to call you. They're your clients in terms of they have the relationship with you. I would have that dialogue with your manager, like, hey, those people in my pipeline, do you want me assisting you? Do you want me to who should I refer them to for questions? I think just an honest and open dialogue with your manager about how to handle that transition period and act in good faith, I think goes a long way. Because a lot of this is when the company feels you're being malicious, that's when I think they go after you. If you're trying to act in good faith, generally speaking, I think most people, they're not going to come after you if you're you've had dialogue on how this is supposed to work and you're operating accordingly.
I believe that
No.
you're 100% accurate. You know, I believe that if you're trying to do the right thing and the company doesn't feel like you're trying to sneak out the door and take stuff from them, they're probably not going to come after you. And listen, I will, admittedly, nobody is going to do all of these things 100% accurately, right? We all live in the real world. But if you try to do the right thing, you're generally going to be okay.
Agreed. We're getting towards the end here, I think. So, any other questions out there? Unfortunately, I think we scheduled this on Veterans Day, so a lot of our banks are closed. So I have a feeling this is going to be a sought after piece of content post Veterans Day. Anyway, this has been a great conversation.
Yeah, it's definitely a slippery slope when it comes to this because loan officers, I just speak being a corporate trainer or a large IMB, and also I train I have a CE school that I have, and every year when I train on New York State component of my continuing education, it always strictly calls out, and I always remind loan officers in my training, do not download material from your company, and do not do this, do not do that. And again, it's so hard because as we know, loan officers they're in sales, we're in sales, and you know, our income is based on commission for the most part, 100% commission for many. And it's that's why it's definitely a very sensitive topic and one to definitely think about because it can have substantial financial issues.
Yep. Like you said, it's financial, it's time, it's aggravation, it's disruption of your business, it's all of those things.
Better to be safer than sorry, right?
Yep, 100%.
Absolutely.
Yeah,
All right.
Found on our YouTube channel, and it's here on the slide that you can see at New York Mortgage Bankers Association. So hopefully folks can revisit this webinar and get some good insight. Thank you both for your time today. Much appreciated.